Would you like me to start the, well, let's see. We can start the live stream and go ahead and do a roll call. And I believe we may have quorum. And just wait.
Yeah. So just give me the heads up when the stream is about to start or when it's ready to start, and I can go through some of the preliminary stuff to
it actually
we are live now, Jamie.
Right. It looks like the I just got a message from IT. It looks like they did just send us live.
Okay. Well, good morning, everybody that's joining us on the live stream. As you probably already heard, we are having some issues with getting members into the meeting. So we're going to give a little time for that to take place. I think there's been a little bit of a change in the procedure of logging in. And while we're waiting for members, I'm just going to go over some, I think I'll call it housekeeping issues, but I'll start by just mentioning that first we have two new members joining us today. Dr. Mike Gilbo from the Maryland Department of Health and Valerie Douglas from Department of Human Services. Welcome to both of you. Normally I give you an opportunity to introduce yourselves, but we are trying to move quickly. I believe that your bios will, if not already posted, should be posted soon. And thank you for your service on this board. As you can see if you've got the materials in front of you, we have an agenda. And today we are going to be first taking up the issue that we started last week, or the last meeting, which is the lower end of juvenile court jurisdiction. We received a number of recommendations from council members, and the procedure that I'd like to follow is that we will have the members that submitted their recommendation give a very brief, hopefully 1 or 2 minute presentation to discuss what their recommendation is, why they obviously support it, and hear from all of them, all of the recommendations on that issue. Not every recommendation that was given was around this issue, so we want to keep those in the parking lot and take those up when those subjects are before the council. I also want to bring your attention to one other document that was in your package, which is the priorities. I think it is labeled JJRC Reform Priorities Schedule. And if you look at the schedule, what we've tried to do is arrange these priorities, and these are the priorities that we voted on in the last meeting, but arrange them in a way that we can get the research and get the presentations put together. So we need some time for some of them, and that's sort of why the order is the way it is. But we also wanted to put those dates on there for all the members so that you could see when we would be likely taking up those issues. And to the extent that we can, we want to hold on to that schedule and have those discussions on the dates that we've got them in the calendar. So I hope that you find that helpful as we move forward. We are going to dispense with the typical introductions. And what I'm going to do is ask Jamie if we've got enough folks on at this point for a quorum to do a roll call rather than introductions. And hopefully by doing that, we can speed up the voting when we get to voting and only go with members that are present. And when we have new members or members come on, as they come on, Jamie will announce them as officially here in the meeting. So Jamie, can you go ahead and do the roll call?
Sure. Secretary Abed.
Present.
Senator Carter. Senator West.
Present.
Delegate Clippinger. Delegate Jackson. Delegate Pippi.
Present.
Secretary Green. Ms. Tolentino,
I'm here.
Mr. Kammer, Ms. Egan,
Present.
Judge Stam, Ms. Douglas,
Good morning. I am actually a new member. Good morning to everyone.
Dr. Gilbolt,
Present. Good morning, everyone.
Dr. Lawson, Dr. Sickmund,
I'm here. Thank you.
Mr. Bayless,
Present.
Deputy Commissioner Michael Sullivan for Commissioner Michael Harrison, Mr. Schellenberger,
I'm here. Good morning, all.
Ms. Davis,
Present.
Ms. Mandel, Mr. Campbell,
Present.
Ms. Chapman,
Present.
Mr. Fonseca,
Present.
Mr. Houston,
Good morning.
Ms. Johnston,
Good morning.
Mr. Ford,
Present.
Mr. McGlone. And that's the roll, Mr. Secretary.
Okay, and Jamie, are we still having issues with people getting on?
It looks like that should be resolved now. I'll go ahead and send out an email to let everybody know.
Okay, well then we can go ahead and get started. The next item on our agenda is approval of the
And-
minutes.
Mr. Secretary, Judge Stam just entered.
All right, welcome Judge Stamm. And just for everyone's awareness, Jamie is going to just announce members as they come on so we can, acknowledge them as present. So if you've had a chance to review the meeting minutes, obviously they're very brief. Our official minutes are the recordings of the prior meetings, but if there are any, I'll entertain any motions on the minutes.
I would make a motion to approve the minutes.
I would second.
Okay, all in favor? Or let me ask this, anyone opposed or have any amendments? Okay, with no opposition or amendments, we'll accept those as passed. Okay, so as I was mentioning earlier in the meeting, we are going to move to the recommendations to the council. And as I mentioned, we're going to have our council members that gave those recommendations give a brief summary or presentation on their particular recommendation, and then we will entertain motions at that point. I believe Senator West is first on the list, and I believe that you were also first in submitting a recommendation. So I'm going to ask you, if you don't mind, and if you're ready to move forward, Senator, to begin.
Sure, and I'll be brief. My recommendation is that the floor on juvenile court jurisdiction would be set at the age of 12, except in cases involving a crime of violence as defined in the Maryland Code. So in the national context, Maryland's one of 27 states, a majority of the states that do not set currently a minimum age of juvenile justice jurisdiction. Further, in recent years, in the last 4 years, 4 states have raised their floor. 2 of them, Utah and California, raised it with exceptions. Utah has quite a few exceptions. California somewhat fewer. In California, the 2 exceptions are murder and rape. Here in Maryland, only 8.8 of the crimes committed by youth under 13 were crimes of violence. So my recommendation would exempt over 90% of youth under 13 from the system. And of those, for youth under 13, there were only 5 commitments in 2019 for crimes of violence. So we're talking about a relatively small number that would still be in the system under the age of 12. However, they would be people who committed serious crimes. And I think we should continue to subject kids who commit crimes like that to the juvenile justice system.
Thank you, Senator. Delegate Pippi, you had, excuse me, the next on the list is Senator Carter. Is Senator Carter here yet?
Hey, Mr. Secretary, I think Senator Carter has a few conflicts this morning, so she won't be on, but may be able to join at some point.
Okay, so I'm going to just read the bullet on minimum age of jurisdiction that she has, which is establishing 13 years of age as the minimum age of jurisdiction. There are other areas that are recommended here, but they don't relate to that minimum age. So we'll move to Delegate Pippi, and Delegate Pippi, I know you had other recommendations, and as I mentioned, we will take those up on those meetings, but if you have anything about the lower bound jurisdiction, please proceed.
Sure. So I'll blame Jamie for the confusion there, because he sent out an email with just recommendations. It wasn't specific to the question from the last meeting, so no worries there. You know, after speaking with our state's attorney and doing some research, this is a very challenging subject because picking any number is very arbitrary, especially given that in each circumstance, you know, you could have a 10-year-old that does something as violent and as calculated as you could have a 13-year-old. But if this group is to pick a number, I want to say the federal number was 11, right? That was the federal number that in the research that you guys put out there. So, I mean, I would say that it would probably have to be 11, and that would not include crimes of violence, similar to what Senator West alluded to in his recommendation. So if we're to pick a number, you know, based on consulting with our state's attorney, based on the federal number and the fact that Maryland does not have a number currently, I would say 11, and then that does not include crimes of violence.
Thank you, Delegate Pippi. Next is Director Fuston.
Good morning, sir. I can be very brief. I align with Senator West's recommendation on the Utah model for 12 years old, with the exception of violent crime as outlined in the state of Maryland. Thank you.
Thank you. And we have Ms. Egan next. You have the floor, Ms. Egan.
Thank you, Secretary. So I wanted to start my remarks briefly by going over the brief that we submitted, but I want to first talk about some of the carve-outs that are being discussed and how arbitrary or not arbitrary the age could be. What we do know is that there is a huge amount of developmental research and science around what this age should and could be. Lots of that revolves around the largest competency study. So the MacArthur Foundation did a huge study of young people to determine whether or not people under the age of 13 understood or could be accountable in the way of adults or even younger teens. What we know is that 1/3 of kids under the age of 13 are not competent to proceed in court. They simply don't understand the difference between doing something that is a no-no or bad and doing something that is criminal. Even if they did understand that, they don't understand what it means to go to court. They cannot, they do not have the working capacity or memory to properly support and assist during a trial. Competency for these young children is a huge issue. And so I wanted to raise that. This is not an arbitrary age. We're not picking an age. There are significant developmental differences between a 10-year-old and a 13-year-old. Science tells us that a 10-year-old cannot be as calculating as a 14-year-old or a 15-year-old. They simply have not developed the cognitive abilities, the impulse control, or those sorts of mechanisms to be as calculating as an older teenager, or even, and especially not an adult. When we talk about crimes of violence, I also want to remind everyone that when you take the adult criminal code and apply it to children, absurdity results. So if we carve out crimes of violence, one of them would be robbery. As a defense attorney, I can tell you, I had a robbery case with a 9-year-old. What happened is that 9-year-old did a trade with a Pokemon card, went home. Their brother told them that they got the raw end of the deal. And the next day that child went to school, shoved the kid who he made the trade with, and took his Pokemon card back. That is a crime of violence. It is a robbery. It was a theft with use of force. So if we carve out crimes of violence, that will be applied to the behavior of 7, 8, 9, and 10-year-olds. It is simply not appropriate to apply that criminal code to young people. And even if they do something that serious, there are systems in place that can support them. Both the children in need of supervision statute would apply to younger children, and the children in need of assistance statute could apply to children. I would also proffer that those systems are better for these very young children, because almost every kid who comes in those very young ages, 7, 8, 9, 10, and 11, has competency raised. And that stops the process for a series of months while that child is evaluated by multiple people, by a defense expert, which is paid for by the state, by DMH. And that is an enormous, huge use of resources. So I just wanted to flag those issues as well. All of that to say is that my proposal is that I want some context and some history for why we should use a specific age and not pick one out of thin air. Maryland, until 1995, followed the common law of doli in capax, which held that children under the age of 14 were presumed to be not competent for criminal court. In 1994, the crime bill changed. The statute had codified that common law and said there is a presumption of infancy for children under the age of 14. And in the 94 crime bill simply erased that. We have a common law and a history in Maryland that we should acknowledge, and that is supported by all of the cognitive research of children under the age of 14. I am proposing that we return to that floor and that we set a floor of 14. I don't believe that there should be carve-outs, but if there are carve-outs, and we can have that a part of that conversation, because the way the code is applied to younger children, and because, frankly, younger children are not as culpable. There are plenty of systems in place to handle even the most serious things that are serious incidents and serious incidents of violence from young people. There are many systems in place to take care of them in a much more appropriate way. And as Senator West and Delegate Pippi pointed out, those are very small numbers of children who would need to be handled by those alternative systems. I would also just note that we are having a lot of conversation about what other states are doing. I would just note that the United States is an outlier in that we set no minimum age, and that the age 11 in the federal system. The plurality of countries around the country set the floor at 14, including almost all of Europe, Russia, China. The floor is 14 in a huge part of the country. When we talk about setting a floor of 11, that puts us in line with countries that simply do not have the history of of civil rights and human rights that we should aspire to in this country. I think Maryland should set a precedent and follow what the science says rather than what Utah is doing. And so that is my proposal.
So Sam, is this the part where we argue about things, or do we just put our proposals out there?
Well, first I want to hear the proposals. There's one more proposal.
Okay.
And
Sorry,
then,
I got confused.
yeah, then we'll take a motion, and upon the motion, we'll have discussion, and we can talk about what age should be. I mean, they all have an age in every recommendation, so that's a variable, and then whether and what exceptions should be applied to it. We can have that in the discussion. Okay, so our last presenter is Dr. Sigmund.
So I also would want to distinguish the juvenile court jurisdiction we're talking about is for delinquency proceedings, because I think you might also want to have a discussion about minimum ages or age boundaries for status offense jurisdiction or your CHINS consideration. You know, the delinquency jurisdiction, I think 14 also is a good age because it aligns with, for most kids, going to high school. So they're experiencing a life transition, and this also makes sense. Just the way the age 18, most kids are getting out of high school, they're becoming an adult in other ways, and that makes sense. It makes sense to parents, it makes sense to kids. I think it will be much easier messaging to actually implement it. And I agree with what Jenny said in terms of the research on adolescent development. It just makes logical sense to me. If you do have carve-outs, I would say those carve-outs also should have minimums attached so that you don't end up with a 6-year-old being charged with murder like California had at one point. The state of Pennsylvania has actually convicted a 9-year-old in criminal court of murder. And then what do you do with that child? Then what do you do with that child? Actually, well, I should say they were charged in criminal court. So a 9-year-old going to state prison? No, that's not going to happen. And if you have a carve out, because it's such a rare event, I think it might create some management challenges for center, for the facilities, because having children that young, it's a different management task because of their young age and their lack of understanding of and just ability to follow rules and everything else. They may take up unusual amount of resources if they were placed in facilities. So my preferred age would be 14.
So Dr. Sigmund, can I just perhaps not to put words in your mouth, summarize your recommendation as consistent with Ms. Egan's? 14 with no exceptions?
For the delinquency jurisdiction, I mean, you tell me whether you want to have it be a separate conversation to talk about, setting minimums also for the status offense stuff, because my preference really would be, and I may be biased, Pennsylvania treats the status offense behavior as dependency matters. So those kids are not offenders. Their families are receiving services to deal with that. That would be my preference for behavior that's not delinquency behavior. But if you didn't want to go that way, I would say you need to set a minimum there as well.
Okay, so we have some, I think, well-formed proposals. I'll entertain any motions, and upon a motion, we can then have discussion on that motion.
Why don't I make a
I move
motion
to adopt Senator West's idea.
Okay, Mr. Schellenberger has made a motion to adopt Senator West's recommendation, which is, let me come back up, setting the age at minimum age at 12. So that would mean children under 12 would be excluded, but 12-year-olds would be included. Is that your recommendation, Senator West?
Yes, but with the exceptions involving crimes of violence.
Okay, we have a motion. Is there a second?
A second.
Okay, discussion. Mr. Schellenberger, I see your hand raised.
Thank you. So obviously in the last discussion, everyone felt strongly about setting a line somewhere. And you know, obviously I didn't succeed in that. I do believe that those who are under this age group, as Ms. Egan has pointed out, if there are competency issues, then the lawyer can challenge competency in the courtroom, and bring forth the fact that that child may not be competent to even be in juvenile court. And let us not forget, this is not an adult criminal record. This is not some place where the Department of Juvenile Services doesn't want to offer services. The only difference is that there will be control through a magistrate or a judge when the individual is on probation. I'm not advocating that 6-year-olds should be, you know, in the Hickey school. I would love to hear if that's happened here in the state of Maryland. Ms. Egan has pointed out that it has. Certainly we can discuss maybe having carve-outs for a certain age and whether they should be in a detention facility or not. But let us not forget that these are magistrates and judges who are making these decisions, and that's why you know, we can't just arbitrarily say, oh no, these don't go in. But I think Senator West's idea of 12 and under 12, but with the carve-outs for, you know, the crimes of violence. And the reason I think we've discussed the crimes of violence is because the legislature has listed those. I mean, until a few years ago, carjacking wasn't one that listed crimes of violence until they added it because it became a more popular crime. So I would be happy to discuss, you know, whether we should make our own list for this, but it's at least when we use the term crime of violence, there's a statute passed by the legislature that tells us exactly what those crimes are. Ms. Egan is correct. Robbery would be on there. I believe she could argue in court that, you know, the pushing and the taking of the card, you know, is really mainly a theft, but she is correct. It does meet the elements of robbery. I don't think I'd put a 9-year-old in my juvenile court, but there are 24 jurisdictions and every one of them is different. And I certainly acknowledge that someone in a different jurisdiction could feel differently. But I think Senator West's approach is a nice middle ground. It protects both sides. And again, these individuals aren't getting a criminal record. So I think it's a fair proposal.
Okay, I believe I saw Mr. Bayless wanting to make a comment.
I guess I have a question and a comment. The question, I guess, is the motion is about the specific suggestion of setting the floor at 12. It seems that the discussion, though, is the discussion. The discussion's about the age itself, and I think my comments would be more general to the whole question. So I can chime in here. I guess I can start with a specific thing about this, and then a more general one. And please cut me off if I'm going too long.
If I could just interject one thing. So just in terms of procedure, we do have a motion and a second. So we do have a proposal that's before us. Now, there is discussion on what I said were sort of the two variables of every one of these recommendations, which is the age, what is that number, whatever we set it at, and then any conditions, whether there are conditions, and if there are, what those conditions would be. Those are sort of our two variables. And so the way that we can proceed is either we can amend the motion, and members may do that if they want to just tweak the number, the age, or tweak the list. But if I think you want to embrace one of the other recommendations, then I would suggest that we would have a vote on the current one. And if it fails, then another motion could be brought to bring that other piece rather than trying to amend our way into that other
Okay.
recommendation. Does that make sense?
Okay. Yeah, I appreciate it. So I'll start by saying I appreciate this recommendation. I don't understand the number based on, especially when we look at Ms. Egan's presentation, which lays out not only what's going on in the rest of the world, but shows how much of an outlier we are. I don't understand setting it at 12. I think, as Dr. Sickman said, there are lots of ways in which we establish transitions within our society that suggest that the age of 14 makes a lot of sense in terms of this. 12 is very young. I also think the other side of this is this issue doesn't sit in isolation. And part of my concern about this is that this shapes what our juvenile justice system is in Maryland. And there are a lot of big issues we're going to talk about, and I'm not going to talk about those issues themselves, but they are big questions for where we're going as a youth justice system in this state. And when we're focused on 11-year-olds and 12-year-olds and 13-year-olds, I don't want DJS's services to be focused on a population of young people when what we need to be worrying about is young people who are making that transition from childhood to adulthood, who we need to be serving in the community and meeting their needs. And so I think that everything we do at the bottom, even if it's not in big numbers, even if it's small, it sets a signal about what the youth justice system is for in Maryland, who it's for, who it should be serving, what types of services we should have. And I think that there's been a strong case made in the last meeting and this one that there are other agencies within Maryland that are better positioned to serve young people at 12, 13 years old than the juvenile justice system.
Thank you, Mr. Bayless. Other discussion?
Mr. Chair.
Yes. Delegate, I'm sorry. I can't see everybody. Is that Chairman Clippinger?
Yes.
Yes.
Would you please, could we again hear exactly what the motion would be? I would appreciate that. Or what the motion is, I'm sorry.
Sure. Jamie,
Yeah,
can you read back the motion?
It would be the floor on juvenile court jurisdiction would be set at age 12, except in cases involving a crime of violence as defined in the criminal law article.
It's a crime of violence under section 14101 of the criminal law article, Delegate Clippinger.
I could just, if I could make one response to Mr. Bayless. He mentioned that Maryland is an outlier and advocates for the 14-year, but I'm looking at the map that we got the last time we met. As I can't find any state that sets the minimum at 14. There are a number of states that set it at 12, but none at 14. So if we set it at 14, we would be the outlier.
You would be the leader. You were an outlier in the world, not within our country.
Yes, thank you. That is what I meant, Senator West. That is a good clarification. That's what I meant about the map of the world and where we are compared to that.
Okay, thank you. Delegate Pippi.
Sure. You know, one of the things we're talking about when you set a hard number, anyone below that number, what options do they have? I mean, hypothetically, if you set it at 13 or 14, that's basically saying that no one under that age is capable of committing a crime, a violent crime. I mean, let's talk about that for a minute. We've got prosecutors and state's attorneys and other participants here. I mean, are we really prepared to say that anyone under the age of 14 is incapable of knowingly and willingly committing a crime and being held accountable for that? I mean, that's what we're really talking about here. I get an argument.
Mr. Schellenberger, can we have Delegate Pippi just finish his remarks and then I'll recognize you.
Question. Sure.
And once he's finished, I'll recognize you.
I'll call on you, Scott, once I'm done. So there's an argument for not having a number only in the sense that you can weigh each case judges, magistrates, the juvenile system, I mean, you have the ability to weigh things. When you put a number out there, it will eliminate some options to some extent. So I hope that we address that issue when we're thinking about picking a number, an arbitrary number for that matter. So that's all I got.
Okay, we're going to go to, thank you, Delegate Pippi. We'll go to Mr. Schellenberger, and then following that, Ms. Tolentino to respond to the question about what services are available if we do not engage the juvenile justice system. So, Mr. Schellenberger.
So Delegate Pippi, just so you know, I can't remember if you were on the last time, but I lost the vote 19-1 last time for setting an age. So I'm a realist. I see Ms. Egan is smiling. I'm a realist, and it clearly was the mood of this committee that we set an age. But what we have done is Senator West has carved out crimes of violence. So theoretically, a 10-year-old could be charged in juvenile court with murder. And that's the whole intent of this. Now, the kind of charges that they could not be charged with would be a shoplifting. So if a 11-year-old goes into the Walmart and shoplifts, that would be handled by other agencies. It would be handled by a SINA petition where a child would be in need of assistance, where the family could get services to deal with that problem. So the idea is that the juvenile system going to court and being in front of a magistrate under that certain age would be limited to those crimes of violence, but it doesn't mean children who commit other crimes that aren't in those crimes of violence would be ignored. They would be dealt with other systems. It's just my position that if you've committed a crime of violence, you need to be in a courtroom and we don't just send a social worker to your house, which we probably will do anyhow through the juvenile system. So that's why there's a carve out, a hard date and a carve out.
And just real quick, agreed, and that's why I put a number with the carve out today as well, because I get the momentum here of the group. But yes, I agree with you, Scott. Thanks.
Okay, I heard somebody speaking, but I'm going to recognize Betsy. Is there anything else? I know Mr. Schellenberger did cover the alternative path. Is there anything else that we needed to cover on that before I recognize the person that was speaking?
Secretary Beck, if I could just say one thing really quickly.
Go ahead.
I just have really very deep concern around us very generally saying crimes of violence, because I know we're focusing on murder and different things like that. But we also know that crimes of violence is very broad. And that also can, when we're thinking about students in school, if I go and I push another student, that can be assault. And so I can end up, or I take someone's phone or something like that, I can end up in front of a judge if a parent or someone else kind of pushes that issue. And so we also know that we heard just now kind of intent, what the intent is. We also know the intent doesn't always equal impact, right? So what is that impact of leaving that as broad as that? And so that's why I think it's really important for us to define what this is, because the intent is not always the impact.
To that example and to some of the examples that Mr. Schellenberger gave, I would just say that earlier this year we had a 9-year-old, and I have permission to tell this story from her and her family, a 9-year-old who was being babysat by an older family member when those older teens committed an alleged robbery. That 9-year-old was charged. She weighed 54 pounds, was arrested, was put in a cell, had an ankle bracelet slapped on her ankle. She was 9. She stood there and was not a participant. But the impact is not just going to court. The point of setting a floor is not just changing the behavior of the courts and DJS, but also the interaction of children and police. It will not surprise anyone on this call that this young woman was a young Black woman, and that 65% of the children under 13 in Maryland who are arrested, handcuffed and caged are Black children. And so when we talk about those carve outs and when we talk about, I think it's more than 21 crimes outlined in the proposal, that would be impact a number of children, not just in what happens to them in court ultimately, but those experiences are extremely traumatizing. We know that a single arrest can can double the rates of high school dropout. These are things that matter earlier in the system than when we get to court. And if we know that the majority of children are not competent, if we know that the vast 90% of kids are never going to be in the system, we should probably stop having police arrest and traumatize them on the front end.
Okay, I'm going to pause for just a moment. We have some members that have been that have joined the meeting. Jamie, can you just quickly mention who has joined the meeting new? And
So,
if you haven't made, go ahead.
The meeting began. We have Delegate Clippinger, Delegate Jackson, Mr. Kammerer, Dr. Lawson, and Deputy Commissioner Michael Sullivan for Commissioner Michael Harrison.
Okay, great. Thank you. And welcome to those that came a bit late. Sorry if you had some technical difficulties. I'm going to recognize Betsy.
Oh, good. I'm off mute. Good morning, everyone. So I just want to speak on the current motion and for a moment, and then I think I'm going to offer an amendment to be considered. First, I do want to just outline very briefly all the other systems that are designed to intervene with young people. We have the Child in Need of Supervision system in Maryland, which by definition is to intervene with young people who may injure themselves, injure others, are habitually disobedient, ungovernable, or beyond the control of the person having custody. The court is even empowered to use shelter care if they needed to for a child in need of supervision and supervise them after a hearing on a petition. We also have the SINA system in Maryland, which is our child welfare system that's under the Department of Human Services. And when we look at the definition of a SINA child, or someone who's considered to be a child in need of assistance, that is someone who is a young person who may have been abused, neglected, has a developmental disability or mental disorder, and the child's parents, guardian, or custodian are unable or unwilling to give proper care and attention to the young person. And there are so many interventions that can be utilized through the child welfare system, through removal of a young person from their home, to foster care, to group homes, to voluntary placement agreements, to family preservation, to alternative responses to preserve and to support families and young people in their homes, evidence-based services, parenting classes, Ready by 21. The list goes on, and that system is really designed to support young people and their families be successful. And then we also have local care teams, which are developed and through statute. And local care teams are in every single county in Maryland. They're formed for families and children who have intensive needs and need assistance, whether it's because of behavioral health needs or other disabilities that may be occurring, assistance through the school system. And those local care teams are made up of every child serving agency in that locality. And it can be very effective in getting young people and families what they need. I very much believe that the juvenile justice system has our most intensive level services and interventions. And those need to be reserved for young people who require them and who are identified as a risk to public safety or themselves. And I believe through our data presentation that we saw last week, we really see a difference when we're looking at under 13 rather than under 12. That under 13 gets us closer to that where the science is directing us towards where we see juvenile justice systems at least being more developmentally appropriate and at least being able to be understood by the young person. And so for those reasons, I am proposing an amendment to the motion, and the amendment would set the floor at under 13.
Okay, we have a motion to amend. Jamie, you sent me a message, and I'm going to ask you just to go ahead and speak up about this. You say there is a procedural issue with the amendment?
Sure. So procedurally, you would need to decide whether or not to adopt the motion that's currently before the council before it could be amended. So it would be, you would adopt it. I didn't catch that, I think you're muted.
I don't know that that's possible. If we adopt the motion, then it's adopted. How would we amend it after?
That's how
Oh, you can continue to make changes to what's before. It's just so that so there's currently a motion before the council. You would either decide to adopt it or reject it, and then you would get to Ms. Tolentino's point.
So in that case, Mr. Chair, I would withdraw my amendment, and I would my comments can be construed to my position of opposing the current suggestion or the current motion to have a floor at under 12.
Hi, this is Rosemary. Given the discussion and the fact that there is an amendment that someone wants to place, I think the thing to do is to call the question, take the vote, and then if it passes or doesn't pass, we can either amend or provide a different suggestion. So I would ask that we call the question.
Thank you, Ms. Johnston. The question's been called. I'm sorry. Yes, Chairman Clippinger.
If you're going to call the question, that's fine. I had one more thing I wanted to say, but.
I'll put it on the table so you can speak.
Okay. I have some, I'll just say I have some questions in my head as to whether the crimes of violence exception for under 12 is overly broad. I think that my recollection when my committee dealt with this issue in 2019 was that the number of people who were actually detained in the state of Maryland for some period of time. We took this issue up in judiciary and we passed legislation that said that you could not be detained if you were 12 or under, unless it was for a crime of violence under 14-101. But my recollection was that the number of kids that we were talking about was incredibly small. So I guess that plays both ways. On the one hand, it's incredibly small, so it's not going to happen that much. The other side of it is it's incredibly small, and what are we really talking about here? So I'm of the inclination that perhaps that is too broad, and I would prefer something a little more narrow if it were addressing issues of cases where kids were alleged to have committed murder, committed some part of that of the crimes of violence. But with that, I will stop.
All right. Well, thank you, Mr. Chairman, and I appreciate your comments. I think they are helpful, as well as everyone's comments. We have had the question called, so I think we should have a vote. If the vote fails, then we can entertain. We have time to entertain another motion. Jamie, let's have the vote.
So the question is on Mr. Schellenberger's motion to adopt Senator West's recommendation to set the floor of juvenile court jurisdiction at 12 in all matters except crimes of violence under 14-101 of the criminal law article. Senator West.
Yes.
Delegate Clippinger.
No.
Delegate Jackson.
Sorry, no.
Delegate Pippy.
Yes.
Ms. Tolentino.
No.
Mr. Kammer.
No.
Ms. Egan.
No.
Judge Stamm.
Abstain.
We missed the last name you called, Jamie. Could you recall that?
Sorry, Ms. Douglas?
No.
Gilbold?
No.
Dr. Lawson? Dr. Lawson?
No.
Dr. Sickman?
No.
Mr. Bayless?
No.
Deputy Commissioner Sullivan?
No.
Mr. Schellenberger?
Yes.
I didn't catch that. Mr. Schellenberger?
Oh, I'm sorry. Yes.
Davis?
I believe you called Ms. Davis.
Oh, yes. I'm sorry. No, my vote is no.
Ms. Mandel?
No.
Mr. Campbell?
No.
Ms. Chapman?
No.
Mr. Fonseca?
No.
Mr. Houston?
No.
Ms. Johnston?
No.
Mr. Ford?
No.
And Secretary Abed?
I'll abstain.
Is there anybody that I missed?
That's everybody, Jamie.
So 19 in the negative and 3 in the affirmative with 2 abstaining. That's the vote.
So the motion fails. Are there any other motions?
Mr. Chairman, I have a motion.
Go forward.
I make a motion to set the jurisdictional limit at under the age of 13, with the exception of crimes that carry a penalty of life without parole, which would be murder in the first degree, rape in the first degree, and sex offense in the first degree.
No.
Jamie, do you have that motion?
Let me repeat that to you, Mr. Secretary. So it's Ms. Tolentino's motion to set jurisdiction at 13 for all but crimes that carry life without parole. You're muted, Mr. Secretary.
I believe that is your motion, Ms. Tolentino. Is there a second?
Second.
Okay, any discussion? I know it's the same discussion. We've had the discussion. We have a new motion.
Question.
Yes. Delegate Pippy.
So in lieu of that, if we looked at the list of crimes of violence and there were a few on there that was concern, robbery, let me see here. Assault, whatever. I feel like that would be more in line, more realistic. I mean, the purpose of having a list of crimes of violence is because society and policymakers in general have held that these are the most serious and serious offenses that we have, and they should be treated as such. We shouldn't just exclude them all. That's the reason carjacking was added on there in the last couple of years. So again, wanted to see if anybody would be willing to go at that route. So if you had the list of crimes of violence and there were a few items on there that gave members concern, removing those, so it would be except in cases of crimes of violence, except, et cetera, et cetera. So just food for thought if anyone wants to comment on that.
Thank you, Delegate Pippi. Any other discussion? Mr. Schellenberger.
Thank you. So we're leaving out armed carjacking. That is, comes up to your vehicle, points a gun in your face, has you get out, and steals your car. We're sending social workers over to their house, and that's who's going to take care of all this. All I'm saying is, let's make sure a magistrate deals with appropriate issues. Arson in the first degree, leaving that out. They set fire to your house. First degree child abuse. A person who causes injury to a younger child. It can be a household member. So it could be a sibling who severely injures the child. We're not going to put them in juvenile court. I mean, I agree with Delegate Pippi. Perhaps, because of Miss Egan's example of the robbery, perhaps we can narrow this list down. But we are, with this motion, leaving out a whole lot of crimes that are pretty serious.
Any other discussion? Ms. Egan?
I would just note that under Mr. Schellenberger's carve out for carjacking, the 9-year-old who was arrested and charged while she was being babysat by older teens would still go into a cell and still be brought before court. I don't think disparaging the work of what social workers do. I think that's what the juvenile system is for. But even the SIN system and the child in need of assistance would put that child in front of a magistrate who can, under those statutes, commit them to DMH, to the Department of Social Services. Those kids don't not go before a magistrate. They simply go in a system that is able to handle and deal with 10 and 11-year-olds, which the juvenile justice system simply is not designed for. And if we set a floor, will be even less designed for, right? These carve-outs mean that we will build a system that doesn't have services or the ability, those rare kids, especially when we set a floor, will no longer belong in that system, because we will be using DJS resources to address older kids whose needs are more significant and who actually pose a longer term threat. And then that's the other thing, is that the severity of a crime does not necessarily reflect the severity of a need for a child, right? Young children can do things very impulsively that have very significant impacts on people. That doesn't mean that they have the same culpability. That doesn't mean that they have the same understanding. And it certainly doesn't mean that they should be dealt with in a system that is, although it's designed to be rehabilitative, is punitive and has some real harm and consequences for young children.
Any other discussion? Chairman Klippinger? Maybe I misread that. Are you?
No, I'm
okay.
I'm pondering. I guess my question, I do have concerns, particularly, let me, if I can, ask a question to Miss Egan. The 9-year-old you're talking about, were they charged with armed carjacking or carjacking?
Armed carjacking, because the child who was babysitting them had a BB gun. Because that's how conspiracy works. That's how, accomplice liability works. Everybody who's there gets charged.
I have concerns in my mind about leaving out, for starters, drawing the line at life without parole and leaving out those where you could be charged with life. I have some concerns about particularly arson And quite frankly, maybe even carjacking too. I hear what Ms. Egan is saying, and I do think that, and I am still learning and learning more about the developmental or the science on the developmental side. I also know some of the challenges that I face in some of my neighborhoods, including just last night. So I have some hesitation about not including those. I do think that the first degree assaults I think there are a couple possession of gun, if I'm remembering right, gun possession. I don't know that they should rise to that level. But having said that, I have some concerns about drawing the line at life without.
Okay, thank you. Ms. Mandel, if you could mute your line unless you have a comment. We're getting some feedback off of your line. Thank you. Does anybody else have any comments? I'm sorry, any discussion?
I just want to raise a question about, it came up in the earlier discussion. This is the flip of what we were just discussing, but is there a minimum age for the exceptions? Wherever we rely on these exceptions, I would suggest we set it based on the conversation that we set it at 11. But I don't know. I think we should talk about it because I think we're still now in a place where, as it was raised before, whatever we set it as, if we set it at, if we include only offenses that carry life sentences, we could still be talking about a 6-year-old or an 8-year-old who we would be bringing in on charges, and I think we need to address it.
Okay, thank you for your comment. Any other discussions? All right, are we ready for voting? Jamie, want to go ahead and call the roll?
We are.
Can we rehear what it is?
So
I got a little off track. Can you just read it again?
Sure. It's Ms. Tolentino's motion to set jurisdiction of the juvenile court at 13 for all but crimes that carry life without parole. So under 13 would not be subject to juvenile court jurisdiction. Can I go ahead, Mr. Secretary?
Yes, please go ahead.
Senator West.
No.
Delegate Clippinger. Delegate Clippinger?
Yeah, I vote no because of the LWOP.
Delegate Jackson?
No.
Delegate Pippi?
No.
Ms. Tolentino?
Yes.
Mr. Kimmerer? Mr. Kimmerer?
Looks like he froze up, so we may have to pass him.
Ms. Egan?
Yes.
Judge Stamm?
Abstain.
Ms. Douglas?
Yes.
Dr. Gilball?
No.
Dr. Lawson?
No.
Dr. Sickmund?
Yes.
Mr. Bayless?
Yes.
Deputy Commissioner Sullivan,
No.
Mr. Schellenberger,
No.
Ms. Davis,
Yes.
Ms. Mandel.
No.
I'm sorry, was that a no?
No.
No? Okay.
No.
Just to be clear, her vote was no.
Got it. Mr. Campbell,
Yes.
Ms. Chapman, Ms. Chapman, I'll come back on that. Mr. Fonseca,
Yes.
Mr. Houston,
Yes.
Ms. Johnston,
Yes.
Mr. Ford,
Yes.
and going back to Mr. Kammerer,
No.
and going back to Ms. Chapman. May have lost Ms. Chapman.
I'm not seeing her on the list. You may need to dial back in.
I'll go, should I mark as not voting, Mr. Chair?
At this time, yeah, I think we should mark it as not voting.
And Secretary Abed.
I'll abstain. Unless it's a tie. Can you give me the count?
Sure, let me tally that up for you. $11 affirmative. Nine in the negative. 1 not voting and 2 abstaining.
Okay, so it appears the yes has it. Have it.
Mr. Chairman, I don't think you have a majority.
I'm sorry. I've got it backwards. I'm getting too many. So the noes have it. Is that correct, Jamie?
No, I believe that was, let's see, for the yeses on the motion, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. You don't have a majority of the council voting for it, but you have more yeses than nos.
Okay, I'm going to defer to if we have a parliamentarian.
Wait a minute. Sam, are more people voting who aren't on the council?
No.
I didn't understand what Jamie meant. Is everybody whose name he read on the council?
Right.
Yes, they are all council members.
Okay.
Those are all registered votes. Those are not non-council votes. I think the point that Mr. Chairman Clippinger made was that it's not a majority of the council. So we have a plurality. So I'm asking, maybe Chairman Clippinger has some advice on parliamentary voting, but does that mean something significant?
Usually, if you don't have a majority, you have to have, in my committee, you have 22 members. You have to have 12 to pass. but I would need clarification, I think, from Mr. Lancaster as to which rules we're operating under at this point. But it's just worth mentioning that, yeah, there appear to be 11 votes, and I think there are 25 members of the council. So something to pass, at least using the rules that we use, it would be 13. But I defer to DLS and to the chair.
Well, you need a quorum to hold a vote. So half the members plus one would be quorum. And of those voting, my experience is that, you know, in JPR, it's of the members who are voting, a majority of those voting would need to vote in favor of something for it to pass.
Okay, so based on the rules, I believe that we do have a motion that has carried. I think I'm going to accept it at that and close out discussion on this matter. And then we are going to move to the next piece of the agenda, which is the presentations for juvenile probation. So, Mr. Robinson, you're up.
Sure. Good morning, everyone. I'm going to share my screen. It looks like my sharing capabilities are disabled.
We'll go ahead and get those up for you.
Okay, thank you. And I'll be brief because this is obviously a very robust conversation. And I think would love to see a little bit more of that conversation happen on the issues of probation as well. Here we go. And so I'm Anton Robinson. I'm a senior planner with the Vera Institute of Justice. I've had the pleasure to have the opportunity to scan some legislation and sort of preface this conversation about probation. We'll get into a little bit more of the data. My colleague will handle that later. But states and localities across the US have increasingly focused attention on youth probation. And that's for two primary reasons. One, because it's the most common disposition in juvenile justice courts, as well as new research has made it very clear how differently young people think than adults. And so on that first issue, on like how prevalent probation is used, we can see that from 2014, about 200 or over 180,000 youth were placed on probation. And those are youth who were adjudicated. So that's not informal probation. The number for informal probation is a little bit more of a recent figure. And as of 2018, 300,000 young people were placed on probation, either informal or formal probation. And then outside of that, we know that many youth interact with probation, even in a pretrial context as well. So it just highlights how important it is that we think of interventions to improve probation, as it certainly has an impact on outcomes for young people. For adolescents and young adults, we know that we should take into account many different factors. So here are some just brief things that we can do. And from reviewing some of the legislation, these ideas bubbled up very often. Limiting formal probation for youth, except for those with the highest needs, providing positive youth development and activities, and encourage success in school, addressing young persons' identified needs and risk factors, and establishing meaningful goals to reduce reoffending. We know that Maryland has already taken that charge, and as have many other jurisdictions across the country. But let's scan ways to see if can get young people out of probation earlier, or maybe even save them from ever going to probation. And so I've been looking at the legislation, and I should say that in some of the interventions that we'll talk about, some of them can be administratively done, some of them might even require culture change. So not all of it, all of the intervention that we would all like to see can happen through legislation, but I did want to highlight a few things that were going on in the country to shorten probationary sentences. So I think about this one as what happens at the time of sentencing, right? And so in New York, there are limits on how long a young person can be placed on probation. So 2 years, that period can be extended. Same thing for Florida, but they've drawn a distinction for misdemeanor cases. So you can imagine that there's an indefinite period of probation for felony cases, or what would be felonies if they were in adult court, but a 6-month limit for misdemeanor cases. And then I also just wanted to highlight a bill. It has not passed. It's in California, to limit the probationary period to 6 months. So this idea of limiting the front end of probation is an idea that's getting some traction, and that might lead to some options for us in Maryland. And then, also related to the length of supervision is how do we get young people off of probation when they're on? And so that's that second bullet. I like to think of that more generally as termination of probation. Again, I'm sort of preaching to the choir. Maryland has some practice for that, but we can advance certain or make it more effective for certain young people, and look to other states and the ways that they do that. A lot of that is done through administrative changes as well. But I did want to highlight that last bullet, which sort of brings up the idea of earned compliance time. And that's referencing a bill that passed in South Carolina in 2012. So it's been in effect now. What they do is they reduce a young person's probationary term by 10 days for each month that they remain compliant. And then finally, I think this is where we could spend a lot of time talking, and an area that has received a lot of attention in all of the reports and all of the evidence out there, which is just to make sure that probation is actually tailored to the specific needs of young people. Maryland has made efforts to do that. My understanding is that we all want to improve those efforts and make them more effective for young people. So things like graduated sanctions, and I'm thinking, of course, of the accountability and incentives management system. We can spend some time talking about ways to make that more effective. Again, that's going to be in many instances outside of legislative practices, but there may be some intervention that we could talk about. So I will limit it there in terms of just a brief scan of the country. Certainly happy to continue the conversation or answer any questions. And if not, we can.
Thank you. Thank you, Anton. Yeah, if there are any questions, we'll take those. And if there are not, then we'll move on to the next presentation on the experiences of probation for Maryland's youth. But let me just pause for a moment to see if there are any questions for Anton before we move to Selena's presentation.
Not so much a question. I was intrigued by the idea of earned compliance as a reward for positive behavior. The bill down in South Carolina that reduces the probationary term by certain days for each month that they're compliant. Can you tell us any more about that? How has that worked? What's been the success story, if there is one?
Yes, I am doing a little bit more research, and I can certainly get back with you on some of those details. But my understanding is is that it has generally been successful from some of the reports that I've read. The thing to keep in mind, though, is that if we have like the appropriate services that young people need to complete and some metrics for determining when they have completed them, we may not get to the point of actually needing, 10 days lopped off each month if we're actually ending probation at the point that young people complete whatever services were specifically designed for them to complete. So I see that it's not competing interest, certainly. I think it sets a good limit to start from, but I think the type of services that young people complete could lead to them being off of probation even before that time would happen.
Okay, thank you. My experience with my child, as well as my experience when I was a kid, is that kids respond positively to the carrot. If you do your chores, you get your allowance. So it would seem to me that if you act appropriately, you're going to get your probation reduced. It makes sense. Thanks.
And I'm glad you raised that, Senator, because that also has been referenced in some of the evidence that it is used as a specific point of incentive and a pretty effective one as well.
So I just want to mention, Senator West, I also was interested in, let me turn my camera back on, that does seem compelling to give that incentive rather than a punitive response to incentivize positive behavior. But I think one of the limitations that we would have in using that here is that we would need to have some kind of definite end to when probation is. And most of the probation orders that we get are indefinite orders. So we would need to have a sort of end point that we were working from to then whittle those 10 days down from. So I think we would need to have some other pieces along with that to make that kind of thing work. Any other questions or comments about, yes, Dr. Sickman.
And this may connect more to the data presentation about what goes on in Maryland, but I know some jurisdictions have had sort of a different focus on kids that are older youth that will be transitioning out of the system to, there's concern, well, if you have a 17-year-old and you're only going to have them for, a limited length of time, you have extended jurisdiction, but the idea of offering services on a more voluntary basis for kids that their probation term has ended, but they may still benefit from certain services that they could get through your agency. I don't know if that's something that you do or you could do. I know Massachusetts does that. They do probably more for the kids that are in placement, but they'll even pay for them to go to college to ensure that these kids can be successful citizens later on.
I'll leave it for someone else with expertise on whether we can do that or not. I think there are some limitations to that as well. But let me hear other discussion. Mr. Bayless.
Yeah, I wanted to build off what Senator West said, only in since this is just the first presentation that we've had about probation. We're coming off this debate about the age, and a lot of that was reflecting on adolescent brain research and what we know from research in general about what works with young people. And I think it's essential that this council have that same conversation when we talk about practices like probation. And it's great that we have Dr. Sickman here, who's just put out this guide from her organization on effective juvenile probation practice for the whole field, something that is really great that this has been updated. But I think, Senator West, you're onto like a hugely important aspect that we typically have probation completely backwards, that we presume that we give young people a list of conditions that they're going to follow. And then when they break those rules, we tell them that they've broken the rules and we can violate their terms of probation, when these are the very young people who we know are breaking rules. That's why they were put on probation in the first place. So it's almost a question of when, not if, they're going to violate a set of rules when adolescence is about testing boundaries and breaking rules, that we know, just as you said, that if we want to help young people make the leap from adolescence to moving forward, that we need to incentivize behavior. We do it all the time. All of us have in our lives, but especially at that age, that we need to do that. And I think it's a really important shift as we get through this and talk about things like length of stay on probation or the amount of time or contact standards and all that. All of that stuff is meaningful, but if we don't get at the core question of what are we trying to do when these young people, whether they're 15 or 17, come in front of us on probation, what is it we're actually trying to do through this experience? I think this will fall short. So I think you open the door to a really important point about how do we actually help change behavior, which is what we're trying to do here. So thank you.
Okay, any other questions or comments before we move on to Dr. Cuevas's presentation?
I have one, just a comment, is that, and again, I'm not sure if it's in this point or the next presentation we're going to have, but just for everybody remember keeping the lens of equity over probation requirements. Certainly the disparities that can exist between parents of means and what they can do for their kids, and parents who don't have the means to, for example, pay off monetary requirements or other, just so that we keep that in mind when talking about probation. So.
All right, thank you, Ms. Davis. Selena, you have the floor.
All right, perfect. Let me share my screen. Okay, so as mentioned, I am speaking about the probation experiences of Maryland youth. So just to go over the data I was working with data from DJS on all probation releases from fiscal year 2019. During this year, there were 1,825 total probation releases across 1,810 youth. This sample was mostly male, with 82% male, 18% female, mostly Black youth. This sample ranged from 8 to 20 years old, with the average age at admission being 15.7 years old. Most kids were coming from Central, Baltimore City, and Metro, with a lower percentage of kids coming from Southern, Eastern Shore, and Western. Most were charged with misdemeanors at 72%, and most were low risk at 57%, with only 15% of kids released from probation being high risk. And so of the 1,825 probation releases, about 98% had supervision level data. And so what I tried to do was calculate the amount of time that kids spend on each supervision level. Because this doesn't happen linearly, kids can go from moderate to high, back to moderate. This is just how much time they spent overall at each supervision level. And these are also conservative estimates. So at high supervision, kids spent about 2.7 months. This involved weekly face-to-face contact for the youth, and then bi-weekly contact with the guardian. At moderate supervision, kids spent about 6 months, just under 6 months, which involved bi-weekly face-to-face contacts each month for the youth, whereas guardians had to make contact monthly. And then the average time on low supervision was about 7 months, which involved monthly contact both on the part of the youth and the guardian. I also explored different community placements that young people had during probation. Of the 1,825 cases, about 70% included at least one additional placement or service in the community. There were a total of about 2,600 distinct community placements for the sample of probation releases. So this is an average about 2 each. What I mean by distinct is if a kid was on electronic monitoring twice during their probation time, this was only counted once.
And so the most common placements for youth in the community was by far electronic monitoring and GPS, with 57% of kids getting that as a placement, followed by some type of family focused program. 46% of youth were placed in that. Lower percentages of youth were placed in victim awareness programs and education focused programs, with about 1 out of 5 youth being placed in those types of programs. Again, these categories are not mutually exclusive. Most youth had more than one placement during the time of their probation. As for the length of stay on probation, the average was 15 months or 450 days. But when you break it down in terms of years, about half of youth were on for a year or less, just over a third for 1 to 2 years, 11% for 2 to 3 years, and then 5% for over 3 years. And then exploring how differences in average length of stay on probation varied. I explored this by different youth demographic and regional and offense characteristics. And so you see that this range for each different category. And so what I did was I placed all of these measures in a predictive model, held everything else constant. And what I found was that when holding everything else constant, the differences that remain are by region and by age at admission. So you see age at admission peaks at 11 years old at 24.7 months length of stay, and it decreases for older ages. And then you see that there are also regional differences in terms of length of stay on probation, with, I believe, Metro and Baltimore City having the highest or the longest lengths of stay. Then this is where the data got a little bit tricky. So I explored what percentage of youth are released for different reasons and how we can categorize these as successful or unsuccessful. And so you'll see that about half of youth had a successful termination where they complied with the conditions of the supervision and then were taken off probation. 12% of youth had an unsuccessful termination. This can either be that they weren't complying with the conditions of supervision, that they went absent without leave, or that they had adult court involvement. Unfortunately, with the data I had, I couldn't break that down into different categories, but that's what falls under unsuccessful termination. And then there's change in supervision. So this can either be a good thing or a bad thing. So we think of success in terms of change in supervision if their last level of supervision was unsupervised probation. This accounted for about 4% of the sample. And then unsuccessful change in supervision would be if they were committed to DJS for a violation, a new charge, or both. This was about 11% of the sample. Unfortunately, there was also 6% of the sample that was changed in supervision, but it was unclear if this was successful or unsuccessful. Work completed was a catch-all category as well. So I'm really just focusing in on cases where I could determine success. And so focusing on these 1,477 cases, 81% of all cases where success could be determined. About 72% of these cases were successfully terminated in comparison to 28% that were unsuccessfully terminated. And then so I went on to explore how probation release reasons vary by region. And what you see is that there are regional differences in how young people are coming off of probation. So you see that the percentage of youth that are coming off of probation because of a successful termination are much lower in Metro and then even in Baltimore City in comparison to other regions, whereas the percent of cases resulting in unsuccessful termination is also higher in Metro and Baltimore City in comparison to these other regions. Next, I explored how average length of stay varies by termination reason, And so successful termination and commitment to DJS both are pretty much on par with the average length of stay of all youth. Kids who result in unsupervised probation, their release date is average release time is shorter at 10.6 months, whereas kids who are coming off due to unsuccessful termination, their average length of stay is just under 22 months. And then so exploring this group of young people who were unsuccessful due to a new DJS commitment. This was again 199 youth who had their probation terminated unsuccessfully due to a new commitment. So 111 of these cases included at least one violation of probation. So within this 111 cases, 87 were for VOPs alone, whereas 24 cases were for a VOP along with at least one new charge. For these new charges that were coming in with the VOPs, most of them were for misdemeanors at 63%, whereas a lower percentage was for these more serious crimes. Whereas for the 88 cases that were for new charges and did not include violations of probation, these were mainly these more serious crimes of violence and felonies in comparison to a lower percentage being misdemeanors. And then finally, exploring how unsuccessful due to a new DJS commitment varies across these different regions. What you'll see is in Baltimore City, a higher percentage are coming in for just a new charge alone, whereas in Western, a majority of kids are coming in for a VOP or a VOP with a new charge. All right, and then that's it. Unless there's any questions that lead me to my additional slides.
Okay, questions for Selena?
I had a question just to understand more the unsupervised probation category that was on the purple on that one like float looking chart as a successful thing. Like, I just need to understand what that is. You're muted.
So I can speak just to how DJS helped me understand the data in terms of what they categorize as unsuccessful versus successful, where that they consider that to be a possible success. I don't know what in practice that looks like, but yeah, it's hard to figure out without more information, and I was limited to what the data included.
I don't know if Betsy or Sam could answer. I mean, it's like if you're unsupervised, but you're still on probation, so they're just like receiving some kind of services, or is it just they're on some kind of status until the money comes in, they pay fines or whatever is going on. But there's very few of them, but they were, that they were successful. Maybe more people need to be unsupervised.
Mr.
Go
Secretary,
ahead,
I was just
Betsy.
going to transfer that to Mr. Fonseca to answer, our regional director.
Yes, ma'am. So unsuccessful usually results in when the youth receives charges in the adult system and they're no longer involved and they can't successfully complete the conditions, or they age out of the system and they haven't completed the system supervision, or if they end up getting committed on probation, like they're on probation and transition to a committed status, that probation is considered unsuccessful because they end up going into a committed and aftercare status.
No, I was trying to understand what it is like for the kids who are on unsupervised probation. The purple.
So that depends on unsupervised probation. Usually, is sometimes in some jurisdictions is ordered by the court, and it requires them to do things. Sometimes the court will say unsupervised probation, complete 20 hours of community service. Once you're done that, the department notifies the court and the case is closed. So or sometimes the youth is on probation and they've pretty much finished everything, but they have restitution to pay. The court will allow us to put them on unsupervised probation and continue to monitor that restitution payment. If they can't successfully complete or pay that restitution at the end of their time, then that will be an unsuccessful supervision because they weren't able to pay their restitution.
Dr. Sickman, I would offer as a defense counsel that that's our most often unsupervised probation is a child who has done every condition that they're supposed to complete, but has outstanding money. Our court will convert a probation to an unsupervised probation to give them additional time. In addition, there are a number of programs that children can only participate on if they are under DJS supervision. So for us in the city, that's a living classrooms, like a GED workforce training program, as well as some of the job training programs. So we have young people who don't need to be on probation, but want to continue the programming that they are on. And so they get converted to an unsupervised probation in order to continue certain programming, pay money, or pay money. Those are the two main reasons I have people on unsupervised probation. I will also note that unsuccessful termination in my jurisdiction isn't just related to adult arrest or juvenile commitment. Often if my kid has not completed counseling or done checked every box, even if they've had no new arrests for 3 or 4 years, our court will still deem that an unsuccessful termination.
Trying to get my head around it. Thank you.
Okay, other questions?
I have a question about, thank you for the presentation. This was really illuminating. And I think I also have questions. I'm not sure if they're for Vera or for the council, really, that get at some of these questions around length of stay and what it's connected to. So we're talking a lot about the importance of accountability and for young people to understand their actions and consequences and what they're doing. I'm trying to put wrap my head around 15-year-old, 16-year-old who's been adjudicated for a misdemeanor and then on average is on probation for 15 months. That's the average. How to tie this experience of everything that comes along with that back to something that happened presumably months before I was even adjudicated, possibly, and given a disposition of probation. This seems like a very long time for young people to be on probation as teenagers. I'm just trying to, a question for DJS, but also for Mr. Schellenberger and others around the decisions to order young people for this much time under supervision and what we are trying to get out of that much time being under probation supervision, because this feels like a potential space where there could be some real change.
So I think that we're moving into discussion, and I didn't want to just recognize Marta if there were no specific questions. No problem. If there weren't any other specific questions about the presentation, we can move into the discussion, and I'll let Marta lead the discussion. But in terms of the setting of these times, I think that the typical case, and we have plenty of practitioners here that can clarify, but it seems to me that most of these are just what is the length of time they were on probation until the termination, because they are generally indeterminate periods of time. So this is, and the reason, if at the beginning of the presentation that Selena gave, we looked at probation cases that had been closed, so that we would know exactly how long, because we do have a lot of open cases, and until we actually finish them, we won't know how long they are, because there isn't a proscribed period at the beginning and it says you're going to be on probation for this long. So I want to just turn it over to Marta to lead that discussion. Marta, do you have any comments before we go into that?
No, I think I think it's pretty clear that the duration question is sort of in its infancy. If we're looking what's happening around the country, that that most states do what Maryland does, which is to have essentially no specific end to probation other than the end of juvenile court jurisdiction, although there is, of course, the ability to move to terminate, which exists here as well. But we're starting to see some experiments with that. We have the example of New York with 2 years. We have Florida, which has a distinction between felonies and misdemeanors with a shorter period of time for misdemeanors. And we have this bill in California that was just introduced this year.
that would limit it to 6 months with the ability to extend that if needed under that scenario. And we had the South Carolina thing, which is definitely big in the literature. It's being talked about a lot in the adult context of probation and parole, the ability to earn good time essentially off your sentence of probation or parole. And so it's a similar concept here, but as the secretary points out, you have to have an end time in which to work off by your, if you're taking 10 days off per month based on moving through on your program, following through on the goals, you have to have an end date to work that off of. So that does require some sort of limit. So any comments or discussion from the group? Melissa?
I think one of the things I always come back to, and this is sort of why I put it in my recommendations, is there a common understanding across this, across the state within the agency for what is the purpose of probation? And I would maybe ask those of you that work for the agency to tell me what that is. I mean, in the purpose clause for your juvenile code, there is language of balance and restorative justice that addresses public safety, accountability to victims and the community, presumably for the harm that has been caused by the offense, and competency development. And rather than just talking about, well, kids are supervised and they receive some services, can you talk about how what a kid experiences while they're on probation addresses the things in the purpose clause that the juvenile justice system is supposed to be doing?
So I think is that directed to me, Dr. Sickman?
Well, maybe, because when you talk about when should probation be done, part of it is, well, what should it be accomplishing? And Nate and I might think it should be accomplishing one thing, but is that what the agency is trying to accomplish? And then there should be markers and measures that tell you, oh, the kids should be finished now, they've done. And it may not, if the court is imposing conditions that aren't aligned with what that purpose should be, then that's a different matter for, different discussion.
Yeah, I think you make a strong point about setting the marker about what our purpose is. And in practice, I think probation has been largely a measure or a activity of surveillance to determine compliance with conditions of court orders. And it has, I think, been used, even if that's not something that's specifically in there, as a punitive measure or as punishment to do that. And I think that the goal that we have here is that we should move towards a system that prioritizes performance or behavior change, because that is what we should be trying to get. We're trying to get youth to behave differently generally than they have been when they were brought to our attention. And so how can we move the culture away from surveillance and sort of the accountability side and more towards supporting kids achieving the goals that we set out for them to do. And I think that's how I'd like to see the discussion framed. And perhaps one thing that we need to do is set a mission statement, if you will, for probation, whether that needs to be in the code or be in something enshrined in the department's documents, is something that we could look at. And I think that recommendations that we get from council members can be more global. It does not have to be just limited to something like what should be the maximum probation duration. I think, excuse me, we could entertain recommendations to engage in probation reform consistent with what we just said. It doesn't have to be something so specific. So I will leave it there and open discussion for anybody else to weigh in on that. Mr. Schellenberger, and then Senator West after.
Quickly, one thing that everyone has to understand is there are times where the person's charged with a felony, but then pleads to a misdemeanor. So that could account for that lengthier time being on probation. That is kind of dictated by the facts of the case and witness availability. So you theoretically could have somebody charged with a robbery who pleads to a theft. And that, makes the record less bad, but doesn't change the facts of the case. So I'm just giving that as an example of a time where that could happen.
And that.
I'm sorry. I'm just going to, I recognize Senator West was next, then Ms. Davis, and then we'll come back to Dr. Sigmund.
Yeah, mine's just a request. I'd like to take a look at the New York statute that sets probationary sentences at up to 2 years, which can be extended. And I'd also like to take a look at the South Carolina statute, which in which earned compliance is a reward for positive behavior. So
sure. We can get those. We can circulate those to the council.
Great. Senator, our partners at Vero will get those statutes and we'll circulate those to the council as soon as we can get our hands on them. Ms. Davis was next.
Yeah, just a brief comment that I think that the things that we're talking about in changing the way that we look at probation, I think we would need to look at probation as an opportunity to intervene. And I think that would be the overall change of attitude towards what we think probation is just an opportunity to change behavior and all the other things that we've talked about. So.
Dr. Sigmund?
Yeah, I mean, I think that if you're talking about, sort of the length as though it's a punitive, a punishment thing only, yes, you're going to say longer, because they did something more serious. A lot of the folks that have been looking at probation reform, probation transformation, even on the adult side, one of the catchphrases that seems to resonate with folks that we talk to is to have probation officers, the business of supervision, be more like coaching and less like refereeing. So I'm not trying to catch the kid doing everything wrong and then sanction them for it. I'm trying to catch them doing stuff right and encourage them to do that more. And it's a mind flip. It's turning things a little bit upside down probably from current practice, but for places that have adopted that mindset, the probation officers find their job much easier to do because it's really hard to surveil a kid 24/7 to catch them doing everything wrong. But if you're looking for them to do stuff right, they'll actually tell you about it.
All right. Thank you, Dr. Sigmund. Mr. Bayless next.
Yeah, and I think to that point, I picture I've just started coaching my 6-year-old soccer team, and there's 9 of them running around. I picture what it would mean if there were 20 of them running around, and how hard that would be. And I think the length of stay issue has a huge impact on the size at any given time of the probation population, which has a huge impact on the size of a caseload of a probation officer. And if we're talking about being coaches and not referees, and not just catching people in the act, but actually being that support, connecting them with Eric's program, with Choice, and with other organizations where it's individualized to the young person. Length of stay is one of those things where we don't think about it all the time, but it has a huge cascading impact on everything else that happens in the system. And the longer young people are there, it means that we have people taking up resources that could be for others. And the intensity, I mean, probation, the point where we're talking about it, probation is an intentional experience where we're trying to do something, then it shouldn't be for everybody, can't be for everybody, and it can't go on forever. Just like a great program like Choice would be able to tell you, you cannot just keep a kid forever and have them be successful. You will be waiting for the moment where they end up inevitably failing because of the expectation of being under the eye of the system for that long. So I think it's a really, really important.
So I think that raises a question of how could we connect youth to services they may need if probation was terminated, they reach their goals but need more services. I think that's something Ms. Egan brought up as one of the sort of drivers of those unsupervised probations. Maybe that's something that we can entertain. Ms. Egan, you had your hand up?
Yeah, I just wanted to zoom out a little bit and talk about whether or not, one, I would just make a request when they circulate the statutes that there are two authors of the most comprehensive reports on youth probation on the call. So to circulate Dr. Sickman and the Annie E. Casey reports on youth probation would be very helpful. So I just make that request as well. My question is for Vera and for Mr. Vallis and Dr. Sickman, whether or not there's any evidence that probation has efficacy. What is it proven to do? And then my question for DJS is there any evidence base to there being a difference or success from high, moderate, and low supervision levels? Is there any reason or is there any positive outcome, not just in terms of supervised or unsupervised or successful or unsuccessful termination, but in actual life outcomes for children? And whether or not lots of the states cited in Vera's research have things short of probation. So often my clients are ordered on probation to complete community service or do a victim awareness class, but they stay on probation for a year to complete programming that could take 1 week. Whether or not there are options and things that are much less than probation that might be appropriate.
Okay, so I got that you wanted Dr. Sickman's and the Casey report included. We can include that. You asked questions about whether we had research connecting or showing a connection between a supervision level and outcomes, positive outcomes. I don't know that we have it based on the intensity of supervision level. I know we've sliced it up a number of ways. We obviously do report recidivism of youth on probation. I don't believe it is graded by the supervision level, and if we have any outcome data, but we may be able to do that. So that's something that we need to look at. There were you had other questions. I think generally for folks, I want to give them an opportunity to respond as well. Were there other responses from members to some of the comments that Ms. Egan made?
I was going to ask if you are able to pull together recidivism information. I mean, it would be useful to see it by you're doing risk assessments, right? So by risk level and then what the kid got, and then, a lot of jurisdictions don't kind of even put the kids that are at lowest risk on a supervised kind of probation. They're doing the short-term programming, whether you want to call it a kind of diversion. We were on a call for another project last couple weeks ago, and a judge in Fairfax County was saying, like, these lowest level risk kids, these misdemeanants, they don't even come to court. They're getting diversion and services before, she's like, I would never even see them as a judge. They're not coming to my courtroom unless they're to the high end of moderate and high. So yes, there's lots of places are doing diversion. There is some research that shows that the more kids are involved in the justice system, the less well off they do. That diversion is considered a promising practice.
Mr. Secretary, if I may.
Yes. Go ahead, Ms. Tolentino.
Right. So I do want to just point out a few things. We do dig into risk level and recidivism analysis in our data resource guide. And if you all just go to the website under publications, page 201, but we can also attach that to an email for you so you can see that because that's also something that's been very interesting to us as we sort of formulate our reforms internally on how we want to supervise young people. I do want to point out a few things, just other options for sort of those other things you can do short of probation. Last legislative session, there was a proposal to empower the stakeholders in the courtroom and the judge to send cases back to intake, back to that first sort of door that you go into at DJS to receive services and supports through pre-court supervision. I think that proposal just didn't make its way through the whole system, given everything that occurred last year with the beginning of the COVID and the pandemic. But I think that might be something that this group wants to revisit and take a look at as an alternative to probation, but still a way for young people who get sort of deeper into the system to still connect with services, sort of in a diversion type format. I also want to point out that when we think about length of stay for probation, it's a tool, right? When we set goals for ourselves, we think about, all right, when do I want to accomplish that goal? So even having that conversation with young people is so much more difficult when we don't say, well, this is what can happen when we reach our goal, or this is when we want to try to reach that goal, or this is sort of our measure of success. And when we think we would actually be able to say we achieved our goal. And so I think it's developmentally appropriate to be able to set some of those limits. Not to say that the limit may not need to be extended. It may need to be. But I think starting with a place is really helpful in how we manage young people. I will also say that our jurisdictions without some sort of structure all act very differently. And when you look at that slide, and you'll see that lengths of stay do vary by where you live. And young people we know can sniff out something that feels unfair in a second. I hear it every day in my household, how unfair I am. And so I think that when we don't sort of have a little bit of those defined structures, it makes it really hard to get the buy-in from young people and their families that this system is fair, that this system is recognizing their accomplishments when it looks so different all over the place and when there aren't sort of those defined sort of backstops. So those were just my comments.
Thank you, Ms. Tolentino. Any other discussion? I see Michael. Are you searching for the unmute button? No, he's not. Okay. All right. Well, Marta, you want to wrap us up?
Well, Secretary, I guess we will definitely get an email with all the items that have been requested from us. So you'll see that. Do we wish to ask council members to submit recommendations about this at this time in a similar process to which we just did with the floor of jurisdiction for further discussion at the next meeting?
Absolutely. That's the idea, and we want to follow the same kind of format. I know that it can be it feels difficult sometimes in the moment, but I do feel like even with the other issue we had today, we did make progress, even if it wasn't to everyone's satisfaction. And so I think the best way to proceed is to come with recommendations. And as I mentioned, we have there can be recommendations that are very specific, like setting a probation limit or an amount of time, something like that. Something that would lend itself to legislation that was very specific, or it could be more global on matters where we want to try to engage in a longer term process, or to encourage the agency or the system itself to engage in some kind of process. So I just want to make sure that we're open to all those recommendations. We will try our best to corral them as best we can into a conversation that is sort of driving towards a recommendation or a vote on a recommendation. All right. With that, that concludes our meeting. We ran a few minutes over, and my apologies. Do I hear any motions for adjournment?
Motion to adjourn.
Seconded.
All right. And unless there are any objections, we will go ahead and adjourn at this time. Thank you, everybody.
Thank you, sir.
Thank you.